Thanks, Michael, and thanks to the Washington Foreign Law Society for agreeing to host this panel. It's a great delight to welcome everyone to a discussion of law and diplomacy, legal advisors, and the lawyer-diplomat. We're glad you're able to join us. By way of background, Professor McGinnis and I served in different capacities at the U.S. Department of State, and we've long talked about collaborating on a book exploring the topic in its various contemporary dimensions and from a practical or experiential perspective. We were delighted that so many real experts agreed to contribute their experiences and insights to the volume. If you're interested in obtaining a copy, just follow the link to the relevant website where you'll find a discount code. We're really honored that three of our truly distinguished contributors have agreed to join us this evening. The Honorable Miguel de Serpa Suarez, who is, of course, the Undersecretary General of the United Nations for Legal Affairs. Professor Mary DeRosa, my colleague here at Georgetown University Law Center and formerly legal advisor to the National Security Council, and Edward Mike Okeke, who currently lead counsel at the World Bank and the author of a superb book on jurisdictional immunities of states and international organizations published by Oxford University Press in 2018. You have their biographies, so I'll only say that all three are true experts and with different experiences and varied perspectives, which should ensure a lively discussion. We asked them to address several possible topics, including the interdependence of law and diplomacy and the role of legal advisors, diplomats, and lawyer diplomats in international law and governance. That's a broad topic. Whether international law creates separate ethical duties for lawyers that are different from the duties they have to their clients or that their principals have, and the role that domestic law, constitutional law, statutory law, plays or should play in facilitating or constraining legal advisors when they work in the international space. Whether they will in fact address these topics and to what extent, we'll find out shortly. We expect that each panelist may talk for 8 or 10 minutes, leaving time for a brief exchange of views among them, and then an opportunity to respond to requests and questions from the audience or for comments. Peggy has graciously agreed to moderate the discussion, so I'll turn it over to you, Professor McGinnis.
Thank you, David. And before turning it over to our distinguished speakers today, I wanted to thank you personally for the collaboration on this book. It's been a wonderful project to work with you on, and I appreciate the role that you've played, both in terms of connecting the Academy with practice within international organizations, within the US government, and just for your personal support and collaboration on this project has been really rewarding and terrific. So I'm looking forward to the discussion this evening. I will be keeping the queue. We received some questions in advance, but there is a chat box available for those of you who'd like to pose questions, and I'll be monitoring that as we go along. I think it's time to turn it over to our speakers for this evening. I believe we're going to call on the Undersecretary first. So Miguel, I'll let you take it away.
And for me, first, I have to thank you and David Stewart for the patience of being the editors of this baby that I'm showing here. It was a pleasure because, you know, everybody likes to talk about their work and what they do, and I have approached my contribution on a very practical perspective, and I try to describe some of the dilemmas I've been encountering as a lawyer diplomat, because that's what I've been doing for 2 decades at least, and without any academic ambition, but trying to describe what is the reality of the legal advisor in the United Nations and the type of questions that we have to face. This being said, I don't know if you want me to pick up on any particular question, or how shall we start this conversation?
Peggy, are you muted? You want to take that? You're still muted. Peggy, you're muted. You're muted.
There you go. I knew that it was going to happen sooner or later to make that mistake.
The usual friend.
Thank you, David. Yeah, so Miguel, perhaps you could comment on the question about the particular role of the lawyer and the legal advisor within the UN system. Your chapter gets into sort of the particular relationship between the legal advisor's office at the UN and the Secretary General, and the work particularly of the Security Council as an organ within the UN. And I think that might be a good place to start. I know that some of our participants today have questions on specific conflicts, particularly the war in Ukraine. But if you want to address more generally that framework, I think that would be a good way to launch the conversation.
Excellent. So the legal advisor in the United Nations has a dual role. It's I have two heads. So I have the function of legal counsel, and I advise the Secretary General, my colleagues, and the Secretary Generals on any legal matter, but also the President of the General Assembly if he needs some particular legal advice, and he usually does in the procedural field. The President of the Human Rights Council, the President of the Economic and Social Council. The relationship with the Security Council is somehow specific in the sense that there is little formal contact. So it's very rare that the Security Council asks for an opinion of the legal counsel. They have their own legal advisors, particularly the 5 permanent members. It's very rare that I come down to brief the Security Council at their request. It has happened 2 or 3 times in the last almost 10 years. But there is a lot of informal work with the members of the Security Council. Now, the other role is the role of a policymaker, because as an Undersecretary General, I sit in the different policy bodies, the Executive Committee, the Chief Executive Board, the Management Committee. So it's a dual role. And I live very comfortable with it. I can very well on my daily activities separate my role as a policymaker, policy advisor, and legal counsel. Even sometimes in the meetings of our board, our executive board, I clarify whether I'm going to talk as legal counsel of the United Nations or as a USG. Now, I know that some people have a very conservative approach to this kind of functions. I have to say that I actually find it makes my work as a policymaker, makes my work as a lawyer much more interesting and much more complete. I personally do not have any difficulties in functioning in both capacities. As a policymaker, as an Undersecretary General, I really appreciate the fact that in the decision-making process, I can make space for a legal consideration. So when I take that role, I take as my main function to make sure that when we are taking decisions, the legal element is already considered in the different stages of the decision. And this will make my life as legal counsel easier, theoretically, because it's more of a preventive action. So the topics can be very general because very, very broad. The UN covers a lot of different activities, and it can, my advice or the request for advice can relate to the more classic topics of public international law, recognition of governments, treaty law, or it can go to other more specialized fields like law of the sea, oceans. So it never gets boring because even after all these years, I'm getting new questions, which is exciting. In what concerns also the specific peace and security role of the Security Council, we also advise on matters of the charter, interpretation of the charter, use of force, self-defense. That type of advice is more provided to the Secretary General himself. who is, by the way, I'm very lucky because both the previous Secretary General and the present one are very interested in legal matters. So they do ask me very often legal questions, which is good. They want to know what is the legal background of some question. And with the members of the Security Council, there's also a lot of informal exchanges on this matter. So altogether, I mean, after all these years, I keep saying this, I think I have one of the most interesting legal jobs in the world, with moments of enthusiasm and moments of frustration like everybody else, but a very interesting and varied job. Back to you, Peggy.
Thank you, Miguel. And I think we may circle back, or I can invite the next speakers to comment on that line between legal advice and policy advice, and the extent to which, it's always clear where that line is being drawn. And maybe different participants in the room might have different views on where to draw that particular line. David, did you want to jump in here, or can I call on Meke to join us here? You're muted now.
Now I'm muted. Okay, good. If I could just intervene to ask a question that's come up on the chat, could you say a word or two about your career path on the way to the UN? How did you get there? And maybe for people who are drawn to that kind of work, what would be a good background to have, training in terms of training and experience?
My way to the UN is a pretty classic one. So after law school, I did a specialization in European law, not in international law. And I qualified as a lawyer because, mid-20s, you want to open as many doors as possible. You don't want to make final choices at that age. And then after a few years in private practice, which were actually very helpful to develop my legal mind and the sense of client, the sense of actionable advice, I started working for the public sector, for the Ministry of Foreign Affairs. And after that was a very classic way to get there. I was in Brussels many years advising in European Union matters. At some point I was appointed Director of Legal in our State Department in Lisbon. And after that it's basically me taking the risk of applying for the job and getting the job. I feel very lucky, but it's I would say a classic way until getting here for a lawyer diplomat.
Excellent, thank you. Peggy.
Great. If I may, Mike, if you'd like to speak next. I know we have a few questions that we got in advance that you may be addressing, and then I may jump in a little after.
Okay, thank you very much, Peggy, and thanks for the Washington Foreign Law Society for the invitation, and a big congratulations to my fellow panelists, especially Peggy and David, for editing this very terrific book. I told them I'm the interloper here in the sense that I didn't contribute to the book, but if I had contributed to the book, I would have proposed a different title: Law, Lawyers, and Diplomacy, because it talks a lot here about what lawyers do in this process, both in the area of lawmaking and the role that they play in their diplomacy. But the title of this webinar, in essence, captures that. So what I'm going to do is basically talk about what diplomacy in this sense means, in the sense that we have international organizations. Diplomacy basically in the classical and the contemporary sense, and the critical role that international organizations play in this process. I will definitely talk a little bit about the role of legal advisors in international organizations. And of course, I will be using the World Bank as an example. What I will say will track a little, well, mostly what Miguel has said, but maybe try to augment a little bit on that. And Miguel will agree with me that any legal advisor is as good as his team or her team. Goes without saying, but I'm saying it anyway. I am not the general counsel of the World Bank, and I don't play one on TV. So what I'm going to say here is basically the role that lawyers play in international organizations, and I'm going to use interchangeably legal advisors, lawyers, legal counsel, or general counsel, because Miguel will agree with me that even in his role, he relies a lot on a very terrific team that he has at the UN, and I'm a bit biased in the sense that I started my international career in the UN almost 30 years ago. So take it with that pinch of salt. It's already clear to us the role that international organizations play in the area of diplomacy or law and diplomacy. A good many conventions or recommendations that we have that regulate international relations, international interactions are normally negotiated under the auspices of international organization. The UN plays a very big role in that. The International Labour Organization, WHO, UNESCO, where I used to work, they do a lot of that work. So it's a very important role. And another critical aspect of diplomacy, as you all know, is dispute resolution. And again, the role of international organizations in that area cannot be overemphasized. But if you want to learn a lot about all this role, there are literature out there that one can read better. What I want to really zero in on is the role of the General Counsel of the World Bank, which would be the UN equivalent of the Legal Counsel. And as Miguel had pointed out, the legal advisor or the legal counsel or the general counsel of most international organizations, especially within the UN system, wear dual roles. In the case of the General Counsel of the World Bank, I'm saying he now because the current incumbent is male, is the senior vice president of the legal department. And this is a very critical role in the sense that in as much as you're the general counsel, providing independent, impartial legal advice to all aspects of the institutional work, you are also the head of a team or a department within the organization. So you are part of the management, you are part of the leadership team. Under the Articles of Agreement of the World Bank, which is like our constitution or the equivalent of the UN Charter, you have the Board of Governors, the plenary body, then you have the Board of Executive Directors, then you have the President as the head of the operational staff of the World Bank. So the President is the head of management. And as Miguel has pointed with the UN example, in the case of the World Bank, the General Counsel is part of the senior management team. So as a result, he is involved in policy discussions and decision-making for the institution. You just can't say that, oh, because I'm the General Counsel, I'm not involved in that process, but it's being able to navigate that role, knowing when your participation or your presence calls for you wearing the hat of a general counsel as opposed to wearing the hat of part of the management team. And what even makes it all the more complicated is that there might be instances where, again, you serve as the legal advisor of the plenary body. So when the executive board of the World Bank requires legal advice on a particular matter, they will reach out to the General Counsel of the World Bank to provide that legal advice. The same could apply with respect to the Board of Governors. So how do you navigate a situation where there might be a slight difference of opinion between the management team and the executive board of the World Bank? So it's a very interesting and intricate aspect of the job, but that's what really calls for the skill set of really being a legal advisor in that setting. And I believe what is most important in that situation is to understand your role as a problem solver. When you are a lawyer, a legal advisor, or a general counsel or legal counsel in an international organization, problems don't come neatly packaged as legal questions. They come with various aspects. A good many of those aspects might be political aspects. And again, I couldn't agree more with Miguel in the sense that he said most times being present in the formulation of policy helps out a lot. It helps out in the sense of ensuring that whatever policy decision is taken is consistent with the governing legal instruments. It's easier to prevent such a situation than not being involved and being presented with a situation where you now have to figure out a way to make something work for the institution. So your primary role is really to solve problems. It's not simply to answer legal questions, and being present at the table really helps in that regard. Another thing that we always use as our guiding principles in those areas is that equally important as problem solving is that your role is to promote and protect the interests of the institution that you serve. But the challenge then becomes, where do you find that interest? In my own case, my lodestar, if you will, would be to look at the constitutive instrument. No decision that you will be taking within the World Bank should be contrary to what the Articles of Agreement prescribe. But the challenge then becomes, what if what the Articles of Agreement prescribe is not clear? How do you navigate that? But that's, again, where the skill sets come. But it's always very important to have a guiding principle to understand what is the interest that you're supposed to protect or promote. Who is your client? And I mean it not in the business sense, but who are you serving? You are serving the institution, but sometimes the institution might be a hydra-headed monster in the sense that, for example, you might have 3 organs that represent the institution. In some instances, some people think, oh, as a lawyer, you serve the interests of management, but that alone is not enough because the institution comprises of management and staff. The institution comprises of management and the plenary organs. So these are all very important and interesting roles. And I started out my legal career in the UN system, and it's the most fascinating thing that I've ever done. And I'm not sure I'll be able to do anything else after that. I don't know if I have gone over the limit, but maybe in the address to particular questions, I might have much more to say on this matter. And thank you.
Thank you so much, Mike. One follow-up question, and I don't know if you want to address it now or wait till a bit later. One of our advanced questions concerned junior lawyers, and you've mentioned, and Miguel's mentioned, that you work on teams, and the senior lawyers have the seat at the table. And oftentimes the junior lawyers are working within a team. And for them, the question of how do you influence the policymaking question, there may be some conservative career protective instincts that kick in for junior lawyers. When is it appropriate in an institutional setting such as the United Nations or the World Bank for those junior lawyers to have a say or to express their views on something that might fall squarely within the policy realm?
Defer to Miguel first. Go.
Miguel's got it. Go ahead, Miguel.
There's no magic solution for that. That depends a lot the way you work and the way that you make your department work as a manager. So what I do in my team, and again, Edward, you mentioned, but I do have a very good team. What I do in my team is to establish a culture of respectful dissent. So before we put out something, I encourage critical thinking around the table. And I do not have a relation only with my different directors. So we work by topics. And in a given topic, when we have discussions, everybody who is working on that file comes to the table, from the P2, which is the most junior rank in the United Nations, to the D2, the most senior one. And everybody is actively encouraged to give their views on all and any aspect associated with the question. So when we finally formulate a given position, all these different views, junior, senior policy, are ideally already incorporated in the position that the office institutionally will take, or that informally I will take in a management meeting. So it's not as much the profile. And I think that conservative instinct that you have mentioned also depends on the legal culture. That protective instinct of legal function versus policy function is probably more present in the Anglo-Saxon world, but that's also a way related to the way the corporations work, the definition of the different responsibilities. I think that in other cultures is not that strong, that instinct. And the way I deal with it is really to try to have an inclusive leadership, in the sense, make people participate in the process of decision making. And I don't know if I'm doing it wrong, but I actually encourage people also to opine on policy matters, because I think it's part of the training of the junior lawyers. And for me, it's very important. The notion that they are not giving advice, or they're not working for an empty world. I mean, they have to understand that the advice has a certain impact, it has a certain influence in a certain solution, and it's important to understand the context in which the advice is going to be given, because I also think the work becomes much more interesting. You know, if they only do the strictly legal things and they only see the junior lawyers a very thin slice of the process, it's less motivating. Whereas if you are around the table and you explain the full question and the implications and what is the opportunity and the use of a given opinion, I felt that extremely motivating for young and junior lawyers. So that's the method I've been using in the office.
And what I could add to that is that it's one thing as a boss, a manager, to have an open door policy, but more important than an open door policy is to have an open mind policy. And what I mean by that is if you hire staff that are competent, you hire them to do a job. They bring a particular expertise to a particular area. They have a contribution to make. You are, as a leader, it is up to you to harness what they bring to the table to the benefit or to the betterment of the institution. The most effective leaders that I've encountered in my long career are those that had the humility to know that they are not experts in everything. But at the end of the day, I always say the decision maker is a risk taker. You own it, you give your views, but if my signature is going on a document, I take responsibility for that. And if anything goes wrong, I'm not going to come around and say, oh, Mary advised me on this, and as a result, Mary, we are all in on this, but an open, collaborative environment is always the best. But as a junior lawyer, you might be lucky someone invites you to the table, but sometimes you have to also invite yourself to the table because you have something to offer. And everybody wants to succeed. Every leader wants to be helped out. And if I have a junior staff member that brings a fresh perspective or something that I'm not aware of, I will welcome that. I'm not just going to dismiss it because that person is junior or they haven't been in the business for 10, 20, or 30 years. So that would be my encouragement to young lawyers. Learn, be open, and crash the party, if you will. And if you bring something useful to the table, then they will keep inviting you back. But if you show up at the table and make a fool of yourself, then that's the end of it.
Thank you so much for that, for those comments. I'd like to call on Mary now to join the conversation. Crashing the party or not crashing the party?
Yeah, so first, thank you to the Washington Foreign Law Society and to Peggy and David first for including me in the book, which I also have right here. And for including me in this discussion. I'm sort of a little bit different role from our first two speakers, because I'm speaking about my former jobs, as I was 2 times the legal advisor to the National Security Council in the U.S. government. So in that role, it's a much more internal role. It's I didn't do a lot of work multilaterally. I sometimes would interact with the legal advisors in other countries on the legal issues we were dealing with, but it is a more inside role nonetheless. And I will say I will compete with both of you for most interesting job ever, legal job, because being the legal advisor of the National Security Council is in some ways most intense and stressful and hard job, but it is also never ever for a moment boring. So my interaction with diplomacy wasn't so much in the conduct of it, but in the being my legal advice to policymakers would affect what they could do diplomatically, and certainly what was happening in foreign policy and diplomacy would generate a lot of really tough legal questions for me and for the other lawyers in the legal advisor roles. When the chapter that I wrote I talked about 3 case studies of very difficult of when in all of these cases, in all the cases I wrote about, uses of force. So crisis situations, major diplomatic issues and foreign policy issues, and how lawyers in 3 different circumstances dealt with the very difficult questions that arose because of in these situations. And I'm not going to talk about the details of those because everybody should read the book. But I thought that I would talk a little bit, and Peggy, David, please clear your throat or wave your hands if I go on too long. But I thought I would talk about some of the lessons or that came out of that, or some of the themes that I think the three case studies raised. One is sort of this issue of the relationship between policy and law for a legal advisor in my role, and I'll start with that. That is one difference from what we have heard from the other speakers, is that I think most legal advisors in the at least U.S. government do see their role as a law role, not a policy role. There's different degrees of comfort with expressing policy views. I would sometimes, but I was very conscious of trying to keep the separation, because I thought that if you don't want people to think, your clients to think, oh, I'm sort of leaning a certain way on policy, because it could interfere with the credibility of my advice. Nonetheless, and that might, not everybody has that view. nonetheless, policy played a huge role. I did not have, and legal advisors in this context, general counsels, legal advisors in the national security area we are every day in the middle of policy. So it's not that we aren't, familiar with it, or we're sort of kind of, ivory tower lawyers who are just getting questions handed and if that were the case, I think that, it would be, the legal advice would definitely suffer if you don't have the context of the policy. So the legal advice was very much informed by policy. And one of the questions, I think it's a fair question, is how much should a lawyer in this legal advisor role, general counsel role, take the policy into account? How much should you want to get to the the answer that your clients want? And I think among some there's a view that at least here in this maybe is an Anglo-Saxon system, but there's some people have the view that lawyers have to be removed and independent, and that somehow legal advice suffers if you care about trying to come out a certain way. I don't take that view. I think in the roles that I had and that others in the government have, that it is important to understand where the clients want to go, and then you can try to get them there. And if you can't get them there the way they're thinking, you can maybe try to direct them else, to a different way. But I don't think there's anything wrong with being influenced by the policymakers' desires. And so that is an important part. And I was in every meeting of the National Security Council, or the groups that deliberate there, so that I would know what was going on, what they wanted. I could stand up and wave my arms around if something was looking like it was going in the wrong direction, or a direction that would raise legal issues. And I think that that is an important part of the role. But of course, if you care a lot about wanting or you care about getting to where the client wants to be, you have to worry about what's the line, where at what point how do you protect yourself as a lawyer from just kind of giving them the answer they want, or finding a way to get there. And in the world that I have lived in, the national security legal world in the US, there are fewer constraints on external constraints on the legal advice you give. I mean, particularly in the domestic law area, so much of it is secret. The courts rarely get involved in the U.S. with national security legal issues. They have there are a lot of threshold doctrines, political question, standing, state secrets that keep courts from getting to the substance. And so there's so much is secret that the public doesn't really hear and sort of, kind of opine and raise issues as much in other areas. So it can be challenging there aren't a lot of checks for you. Some of there are a variety of ways to deal with that. The most important is to understand it, and to understand your role isn't just to get to yes, but to try to help them get where they want to go in a way that's legal. The contribution that I made in the book talked about 3 different times when there were very difficult questions, and lawyers got to an answer that allowed the clients to get to where they wanted to go. And maybe that wasn't the sort of first the answer, the way they got there wasn't the answer you would get to necessarily right away. But they did, and I analyzed why, what they did, and also some of the risks to those different approaches, because there are risks. Creativity is very good as a lawyer in this area, but you can get too creative. If you get so creative that you're kind of going past the line, then that can be an issue. Also with international law, there is particularly with novel issues like, say, cyber or maybe AI. When we get it, the law and policy in that area is so is very, is a question about, for example, what is a use of force in cyber? What is that a law? What should the U.S. government position be on that? Is that a legal question? Is that a policy question? It's kind of both. And so there's a little bit more a kind of leeway and malleability, but you have to still be aware of the lines. There was a question. Am I going too far long?
You're good. If you're answering, go ahead.
Yeah, so I was just gonna, one of the questions that came up beforehand just sort of triggered something, that was that there was a question of what is the relationship between law and morality? And of course, that's a big question, and I will not pretend to be able to answer it. But I think that there are a lot of times that people, ideally and theoretically, law and morality track. The law is there to help get to the right result. In fact, in my experience, and I think probably everybody, there are a lot of times where at least what seems like the right answer is not legal, or what seems like a terribly immoral thing is you can't, as a lawyer, say that it's illegal, and so in reality, although you want them to be going in the same direction, and I think usually they are, it's not. At least my view on that is that it isn't. They don't track entirely, and that can be a very frustrating situation. So I'll stop there.
So thanks so much. So I have one immediate follow-up to that comment, which is on the question of what we might frame as legal policy, right? These areas where either the domestic law, in the case of giving advice to the government, whether the separation of powers question or maybe a statutory interpretation question is unclear, but even more particularly in public international law, where either it's a novel question or there is great contestation over, for example, humanitarian intervention or the scope of certain uses of force outside a UN Security Council authorization. And combine that with the lack of oversight, the lack of sort of the external oversight. We had some other contributors to the book, and I'm thinking about Harry Aitken's chapter, Mohammed Halal's chapter, thinking about ethical frameworks for legal advisors. And that is, at the end of the day, what informs your own kind of, taking your own temperature. How do you frame your own legal advice in the absence of the kinds of sanctions you might have if you were litigating before a domestic court, or engaged within a corporate advisory role where you have corporate governance rules, it's sort of serving as that check. So I don't know if, and I open that up to both, to all three of the contributors here. What do you consider your ethical framework for dealing with those questions on the edge Mary described as sort of not going over the line? When do you know you're too close to the line? When are you over the line?
I can start. Yeah, a couple of things. That as what developed over my time as a national security lawyer, I can't say that I always have had this philosophy, but I particularly in this area came to the view that I should be at least in the first instance and most instances, except for maybe some extraordinary circumstance, trying to give the client the advice that I think is the best view of the law. Now, of course, what is the best view of the law? That's not always clear. You have, 5-4 Supreme Court opinions all the time, and it's not always that clear. But to genuinely be, to be trying to not just say, okay, this is where I want to go. What's the best way to get there? But what is the law telling me? And then, to genuinely have that as the goal, and understanding that being creativity is a part of that. And then just, this, I don't know if this is an ethical, this is more a protective mechanism, but I would always, particularly in this area, where you have so little external, you kind of try to imagine what would this look like if it were in the New York Times? What would the criticisms be? You put yourself maybe or others in the position of, arguing the other side, devil's advocate, and trying to be really aware, because it's very easy sometimes to just kind of be comfortable. Yeah, and as much as possible in this context, to work with other lawyers and hear other opinions and have some kind of ability, deliberative, kind of process among lawyers. And I always tried to do that.
Do either of the other two want to jump in on the ethical framework question?
I have something to say, but I defer to Miguel first.
Edwards, and then you get some more minutes to think, because this is a difficult one. No, and I think the replies are different depending on the specific job that you're doing. So my ethical reference is the Charter of the United Nations, the values of the Charter, the human rights framework, and for any specific ethical questions that I may have while performing my job, I do have an ethics office with whom I can start a conversation. But I think the question that Mary was talking about relates a little bit to what I have tried to explore in my contribution on this episode of the illegal but legitimate, this kind of, which I think this kind of somehow artificial choices that one should be doing between something illegal but illegitimate. And, we are all creative, and in the international sphere, you have to be creative because many times you're dealing with problems without an explicit legal solution out there. Mary just mentioned cyber and artificial intelligence. We're just starting that process at the international legal level, and many of us don't have the answer. We're still looking for the answers. Now, it's important to be creative, but it's very important to keep in mind that a lawyer cannot be an advocate. And whereas I can be unhappy as a global citizen that international law has not developed to a stage that I would think ideal as a lawyer, and to properly do my job, I have to stay within the limits of what I think is the law. Otherwise, that will contribute, if you don't do that, you will contribute to the erosion of international law, because the consensual element of states around a set of rules that they accept of international law is the basis of our work. And we have to be very mindful of that. Even when you take a position that someone may qualify as conservative, and you may suffer some public abuse because of that. But again, at least in my job, if you have thin skin, you should not accept the job, because there is also a margin of public abuse that you have to to be able to accept. And Peggy, you mentioned cases that are very important, humanitarian intervention. Do we have a humanitarian intervention under international law? So how would I answer that question? My immediate tool of search is, what is the state practice? What are the political bodies of the United Nations saying? And so on and so on. Another example, the Syria cross-border, absent the consent of the Syrian state or a resolution of the Security Council, can you go ahead and deliver humanitarian assistance? And you know the controversy that is out there, and talking about a legal opinion that I've not given, but that's okay. But, you know, so these kind of borderline issues are delicate, but most times they are artificial. You are not supposed to choose between one and the other. And what they do represent most times is a conflict between divergent interests, also inside the United Nations. And that's what I've tried to describe, because these tensions can be creative to a certain point. You know, we have to be able to talk to the different sectors of the organization. And in a political organization such as the United Nations, who has to deal with a complex reality where different factors have to be taken into account, political, human rights, peace and security, legal, you have also internally to find some compromises between the position of the United Nations. Some people know how to play this game. Some people are less good playing this game. And by the end of the day, there's something I tell my lawyers and myself, is that we all have to be politically and diplomatic educated. We have to understand what is the politics out of there. This is not a problem in the United Nations. Even for lawyers, most people are very well informed because that's why they are in the United Nations. But the only thing that the lawyers cannot do and should never do is to try to solve political issues or to accept as legal issues something which is eminently political. And so that's the limit. No advocacy, because that will affect your credibility as a lawyer and that will erode international law. And do not accept under the cover of a legal issue something which is eminently political and is not for the lawyer to solve. So that would be my take on this.
Okay, let me start out by saying that lawyers are not infallible. All we are trying to do is to solve problems to the best of our legal knowledge. When you're involved in policy formulation or decision-making, what you're trying to do is to provide the proper legal framework to facilitate that process. Without getting into the philosophy of moral and law, when you work at an international organization, the UN system, for example, we have the standards of conduct for international civil servants. So while you're an international civil servant, first and foremost, and that imposes ethical duties on you. And the three most critical ones, in my view, which you will find in the staff rules or regulation of most international organizations, is integrity, impartiality, and independence. But where the rub comes is if you're in a situation and a legal advice is being sought, but if you see your role primarily as a problem solver, the easy case is where you are presented squarely a legal question, you present a legal question and you go home, but that doesn't really solve a problem. So as a lawyer, we always say that legal reputational risk is not a legal question. Yes, it's true, but if you're giving an answer to a legal question and you can detect a reputational risk, I think it should be incumbent on you, and you should even have an ethical duty, in my view, as a lawyer, to point that out. And the colorful word I normally use to say that is that you should be able to say that something is lawful but awful at the same time. So it's not everything that is lawful that you should do. You point it out, and at the end of the day, somebody has to take a decision. So your role really as a lawyer is basically understanding that distinction that yes, you can come up with legal advice, but at the end of the day, we are here to promote and protect the interests of the institution, the organizations that we serve, and we are doing the best we can with the knowledge that we have. In some instances, this might not be that clear-cut. Then you might have a wiggle room, as the saying goes, reasonable people can always disagree. Or like the example that Peggy gave, a good many of our Supreme Court decisions in the United States are decided 5-4. It doesn't mean that the 4 in dissent don't have an understanding of the law, but it's just the way things are. But I think the most important thing that has always helped me in my career, where I think my advice is always valued, is because I am always striving to solve a problem without necessarily getting too creative, because the worst thing you can do in this situation is to solve a problem and create a new one. Then you haven't really solved anything.
Great. Thank you. I'd like to invite some of the audience. We have about, I think, 3 minutes left. If there are any other questions, you can post them in the Q&A. One thing that's on my mind just from the last comments, and I don't know if it's folks want to take a few seconds to answer, is the question of what if you give the advice that something is unlawful, and then to the institution or the client, if it's a advice to a state, goes ahead with the illegality or what is deemed, at least by in good faith interpretation, illegal. What then? Go ahead, Miguel.
Easy. It never happened to me so far. Not good. I think that we lawyers, we have to be a little bit scary also. So I never had that situation, and especially not in the United Nations while serving as legal counsel. It also depends the way you deliver. But when you close to a red line, you have to say it very clearly. And again, coming back to the creative, I'm creative, but as I tell my team and my colleagues, there's something I never do. I never compromise on principles.
I guess I can, if really to agree. I also honestly cannot think of any time that I gave advice and it wasn't taken. And I agree with everything that Miguel just said. I would say also, you know, including how you have to be scary and you have to, which is, I mean, I'm not that scary, but you have to, you know, you have to try. And I think also, and this kind of gets to what one of the things that Miki was talking about is in addition to saying this is, you know, this is the answer, give them all the reasons why it's in their interest, you know, that this is, you know, these are the things that could happen. This is, you know, way it'll look like in the New York Times, or this is the, you know, this is the precedent you're going to set, or something like that. And so you give them more than just this is the legal answer, but why it's in their interest.
I think that's a great note to end on. David, do you want to wrap up the session here?
Well, I'm not sure I can wrap it all up because this has been a really fascinating discussion. I'd add 2 more comments, maybe 3 short ones. One, we've talked a lot about the idea that the lawyer isn't or shouldn't be an umpire, that is simply standing by and saying, this policy is good, this policy is bad. That doesn't work very well. You're not going to have many clients once you do that. I think the object of the lawyer is to try to get the client where she wants to go in a manner, it's close to the goal, in a manner that is consistent with the law. And I would add that, at least in my career, I felt that one of my responsibilities was to promote the development of international law in positive, helpful ways. Clearly acting contrary to whatever that might be is not a good idea. So I thought that, at least in the context of our foreign policy, compliance with international law and promotion of international law was an important thing. So it's not just a matter of saying yes or no or being an umpire. I think you have to be creative. A good lawyer is creative and figures out ways to do it, because the client presumptively doesn't want to violate international law in almost all cases. The other thing I would say is that it really matters in the context in which these issues arise. We've been talking primarily about institutional context. Of course, if you're in the diplomatic service or the foreign service, these issues come up in a somewhat different way. And I just point out for some of those in the audience who may not know, in the US practice and in a few others, the lawyers are separate. We are civil servants, not foreign service. One rationale for that, it's not the only rationale, is that we are not beholden to the ambassador for our career the way an ordinary foreign service officer might be. It gives us a little bit more independence to say no or not that way than it would be. Other nations have combined lawyer diplomats, and they serve in posts at home in the foreign ministry as well as abroad. That has benefits that accrue to the individuals in ways that our civil service, foreign service divide doesn't have. So there are merits and limitations on both ends. What I enjoyed, and this is the last comment I'll make, what I enjoyed mostly about being in the State Department and working with foreign service, two things. One, the foreign service, by and large, around the world, is a superb group of people. They're well educated, they're very sophisticated, they're very thoughtful. I won't say that all of them are that, but by and large they are, and they're a wonderful group to work with. Very bright, very dedicated, very thoughtful. If you, and I'm speaking now to the audience, the younger folks, if you're called to the international scene, if you think international, foreign relations and working with people from different cultures and different backgrounds is something that interests you, there's nothing more fun than working in the international space. At the end, my friends thought I was very strange, but I like nothing better than a good multilateral conference. In a room with 100 and 150 countries, trying to figure out what does everybody want? Where's the sweet spot? Who's trying to do what to whom? How can I make this work? With people from all different kinds of legal societies and traditions and careers, figuring out that the way I was trained as a US lawyer is very strange. It's not the norm, and having to get along with people from the civil law or other backgrounds, trying to see if you could find the solution to the problem and be creative. That was the real challenge. So just I wanted to put out for the audience, I'm sure most of the audience knows this instinctively, but this idea of the tension between law and policy, lawyers and policymakers, is one dimension, and certainly that's important. But the other thing about being a lawyer diplomat or a diplomat lawyer is the really fun stuff that I enjoyed. There's nothing, I became a junkie for a multilateral negotiation, really hard, but wow, what fun it is. So if that's calling to you, I'd be happy to talk with any of the people on the audience who want to extend that. So thank you, Peggy, for letting me go on for a little bit over time.
No, thank you. And let's thank our fantastic panelists for their contributions this evening. So all around. And thank you to the Washington Foreign Law Society, and thank you all for being here tonight.
Thanks. Goodbye.